Seconds to go. Start. Open justice is premised on the notion that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Stop. The duty of judges to give reasoned decisions lies at the heart of this commitment. Stop. Questions of the grant of bail concern both liberty of individuals undergoing criminal prosecution as well as the interests of the criminal justice system in ensuring that those who commit crimes are not afforded the opportunity to obstruct justice. Stop. Judges are duty bound to explain the basis on which they have arrived at a conclusion. Stop. Para. Where an order refusing or granting bail does not furnish the reasons that inform the decision, there is a presumption of the non-application of mind which may require the intervention of this court. Stop. Para. In the present case, the High Court has merely observed that bail was being granted after considering the submissions and having regard to the larger mandate of Article 21. Stop. There can be no manner of doubt that the protection of personal liberty under Article 21 is a constitutional value which has to be respected by the High Court, as indeed by all courts. Stop. Equally, in a matter such as the present, where a serious offense of murder has taken place, the liberty of the accused has to be necessarily balanced with the public interest in the administration of criminal justice system, which requires that a person who is accused of a crime is held to account. Stop. Having regard to the settled principles which govern the grant of bail in a matter involving a serious offense in a case such as the present, we are of the view that the order of the High Court does not clearly pass muster. Stop. No case for the grant of bail is made out. Stop. In granting bail, the High Court has failed to notice relevant considerations which ought to have been, but have not been taken into account. Stop. In the above circumstances, we allow the appeal and set aside the impugned judgment and order of the High Court dated 25th February 2020. Stop. As a consequence of this order, the second respondent shall surrender forthwith. Stop. Para. The position aforesaid equally applies to the present case too. Stop. Moreover, when the jail granted to co-accused person has been disapproved by this court and such grant of bail to co-accused had been the only reason for which the bail was granted to the respondent number 2, the impugned order is liable to be set aside. Stop. Para. The submissions on behalf of the respondent number 2 that there was no proper contest on behalf of the said co-accused in this court could hardly take away the substance of the dictum of this court. Stop. It is clear that in said case, the High Court had proceeded in a rather cursory manner and without regard to the salient feature of the case at hand, being that of gruesome daylight murder of the son of the appellant with 8 grievous injuries, including those of incise wounds and stab wounds on and around the neck and the chest. Stop. Para. As regards the case of respondent number 2, we are constrained to observe that even if the High Court proceeded to consider the fact that the co-accused person had been granted bail, at least this much was required, that the relevant facts of the case were indicated, as also the reasons as to how the case of respondent number 2 was treated to be identical. Stop.